The United States government has just expanded one of the most sweeping and most controversial visa policy changes in recent memory. And if you or someone you know is a citizen of one of the countries now targeted by this new requirement, what we are about to tell you could change your entire approach to applying for a U.S. visa. The State Department has extended a $15,000 bond requirement to citizens of 12 additional countries, meaning that travelers from these nations who apply for certain U.S. visas will now be required to post a financial bond of $15,000 before their visa can be processed or their travel authorized. This is not a visa fee. This is not a processing charge. This is a cash bond, $15,000, that must be put up as a financial guarantee that the visa holder will comply with the terms of their visa and return home when required. The implications of this policy for individuals, for families, for businesses, for international students, and for tourism are enormous. And the expansion to 12 more countries means that the population of people directly affected by this requirement has grown significantly overnight. Stay with us, because we are going to cover every single aspect of what this means and what people need to know. Hello, everyone, and welcome back to U.S. Benefits Update. I am your host, Claire Hollister, and thank you so much for joining us today. This channel covers immigration updates, government policy changes, and the financial and legal implications of decisions that affect the lives of millions of people. Today's story sits squarely at the intersection of all of those topics. The $15,000 visa bond requirement is one of the most consequential and most discussed visa policy developments in current U.S. immigration history, and its expansion to additional countries means that more people than ever need to understand exactly what it is, how it works, who it applies to, and what options exist for navigating it. Please stay with us all the way through, because the sections on who is affected, what the financial mechanics look like, and what the real-world human impact is are going to be essential for anyone connected to the countries now covered by this requirement. Here is what the State Department has announced and why it is generating such significant attention from immigration attorneys, diplomatic circles, and affected communities around the world. According to recent media reports and State Department policy announcements, the $15,000 visa bond pilot program that was initially introduced earlier in the current administration's tenure has been extended to cover citizens of 12 additional countries. Multiple international outlets are reporting that this expansion significantly broadens the geographic scope of the bond requirement and brings the total number of countries subject to the policy to a substantially larger group than when the program was first implemented. The visa bond requirement, as structured under current policy, applies to applicants for certain non-immigrant visa categories from the designated countries. When a citizen of a covered country applies for a qualifying visa at a U.S. consulate or embassy, they may be required to post a bond of $15,000 as a condition of visa issuance. Recent statements from State Department officials suggest that the bond is designed to serve as a financial deterrent against visa overstays, which occur when a visa holder remains in the United States beyond the period of authorized stay indicated on their visa or their I-94 admission record. The bond is structured to be forfeited if the visa holder overstays, and returned if the traveler departs the United States in compliance with their visa terms. But that is not the full story. The policy has also been discussed in the context of a broader set of diplomatic and immigration enforcement priorities that reflect the current administration's approach to managing visa compliance and immigration integrity. Latest developments indicate that the State Department is treating the bond requirement as one tool within a larger toolkit of measures designed to increase accountability for visa holders from countries that have been identified as having elevated rates of visa overstays or other compliance concerns. The expansion to 12 additional countries suggests that the administration views the initial implementation as having established a template that can be applied more broadly as a matter of ongoing immigration policy. To understand why this policy exists and how it came to be, we need to look at the background of the visa overstay problem in the United States and the policy responses that have been developed over time to address it. Visa overstays have long been one of the most significant sources of unauthorized immigration in the United States. And according to data that the Department of Homeland Security reports to Congress on an annual basis, hundreds of thousands of people overstay their authorized period of admission each year. The countries from which these overstays originate have been tracked and categorized, and the bond requirement is designed to specifically target the nationalities with the highest overstay rates. The legal authority for the visa bond requirement comes from existing statutory provisions in the Immigration and Nationality Act that give the Secretary of State and the Secretary of Homeland Security authority to require bonds as a condition of visa issuance in circumstances where the government determines that such a requirement is appropriate to ensure compliance. This authority has existed in the law for many years, but was used only rarely and in individual cases rather than as a programmatic requirement applied to entire nationalities. The current administration's decision to apply the bond requirement on a categorical basis to all or most visa applicants from designated countries represents a significantly more expansive use of this authority than has been seen in recent history. The pilot program was initially launched targeting a specific set of countries, and according to recent media reports, the results of that initial phase informed the decision to expand the program to 12 additional nations. However, what happened next is even more surprising than many observers anticipated. The expansion was announced with relatively short notice, meaning that applicants who were in the process of preparing their visa applications or who had interviews scheduled at consulates were suddenly confronted with a new requirement that had not been in place when they began their application process. This created significant confusion and disruption for affected applicants and their legal representatives, and immigration attorneys have reported a surge in inquiries from clients trying to understand whether the new requirement applies to them and what their options are. Let us now be specific about who is affected by the visa bond requirement and what the scope of the impacted population looks like. While the State Department has not always published a comprehensive list of all affected countries in a single, easily accessible public document, recent statements and reporting provide important context for understanding the reach of the policy. The bond requirement as structured applies to citizens of the designated countries who are applying for non-immigrant visas, meaning temporary visas, at U.S. consulates and embassies. This includes the B1 and B2 visa categories for business and tourism, which are the most commonly sought non-immigrant visas. It may also apply to other non-immigrant visa categories depending on the specific policy guidance that has been issued for each country. Citizens of the designated countries who already hold valid visas issued before the bond requirement took effect may not be required to post a bond for that existing visa, though they would be subject to the requirement when they seek a renewal or a new visa. The practical question of who specifically is affected depends critically on which 12 additional countries have been added to the program, and the State Department's announcements and official guidance are the authoritative source for that information. Citizens of the originally targeted countries and now the 12 additional countries who are planning to apply for U.S. visas need to consult the current State Department guidance and their nearest U.S. consulate or embassy to determine whether the bond requirement applies to their specific situation, visa category, and country of citizenship. It is also important to understand that the bond requirement does not apply to travelers who are citizens of visa waiver program countries, since those travelers enter the United States without obtaining a visa in the first place. The bond requirement is specifically about the visa issuance process, and VWP travelers from designated countries are in a separate category. However, recent statements suggest that the administration has been reviewing the overall structure of the immigration compliance framework, and advocates have raised concerns about whether additional compliance requirements could be considered for VWP travelers as well in the future. The financial mechanics of the $15,000 bond requirement deserve careful and detailed explanation because understanding exactly how the bond works, what happens to the money, and under what circumstances it is returned or forfeited is essential for anyone who is considering whether and how to navigate this requirement. The $15,000 bond is a financial instrument that must be provided to the U.S. government as a condition of visa issuance. In practical terms, this means that the applicant or a sponsor on their behalf must make available $15,000 that will be held by the government during the period of the visa. The specific mechanics of how the bond is posted, whether through a cash deposit, a bond from a financial institution, or some other mechanism, are governed by the specific regulatory guidance that has been issued for the program, and applicants should consult the official State Department guidance and potentially an immigration attorney for the most current and accurate information about the posting process. The bond is structured to be returned to the applicant or their sponsor if the visa holder complies with the terms of their visa, including departing the United States on or before the date that their authorized period of stay expires. If the visa holder overstays or otherwise violates the terms of their visa, the government has the authority to declare the bond forfeited, meaning the $15,000 would not be returned. This forfeiture mechanism is the financial deterrent that the policy is designed to create, making the cost of non-compliance concrete and significant in a way that a simple visa denial or deportation proceeding might not. However, the policy raises significant practical concerns that immigration attorneys and financial advisors have been quick to highlight. $15,000 is a substantial sum of money that many visa applicants from the affected countries simply may not have available to post as a bond, even temporarily. For many applicants from countries with lower average incomes, $15,000 may represent many months or even years of earnings, making the bond requirement effectively prohibitive for a large portion of potential applicants, regardless of the legitimacy of their travel purpose or their intent to comply with visa terms. Critics of the policy argue that this financial barrier will disproportionately exclude legitimate travelers, tourists, students, and family visitors while doing relatively little to deter the most determined bad actors, who may find ways to circumvent the requirement. The policy also has significant implications for businesses that rely on international visitors, including the tourism industry, the hospitality sector, conference organizers, and universities that host international students and researchers. If citizens of the designated countries are deterred from applying for U.S. visas because of the bond requirement, the direct economic impact on these industries could be substantial. Recent analysis from travel industry associations has highlighted concerns about the potential reduction in international visitor volumes from affected countries, with estimates suggesting that even a modest reduction in visitor numbers could translate into significant losses in tourism revenue. The timeline of the visa bond requirements development and the expansion to 12 additional countries is important context for understanding where the policy stands now and what to expect going forward. The initial pilot program was implemented earlier in the current administration's tenure, and according to multiple international outlets reporting on the expansion, the decision to extend the requirement to 12 additional countries was implemented on an accelerated timeline that gave affected applicants limited advance notice. For visa applicants who are currently in the process of applying for U.S. visas or who have upcoming consular appointments in countries that have been added to the program, the immediate practical question is whether their pending application or scheduled appointment is subject to the new bond requirement. The answer depends on the specific effective date of the expansion for their country and the current guidance from the U.S. consulate where they are applying. Applicants in this situation should contact their consulate directly and should consider consulting with an immigration attorney to understand the implications for their specific case. Looking ahead, there are several important developments on the horizon that could affect the trajectory of this policy. Legal challenges to the bond requirement have been filed or are being contemplated by civil liberties organizations and immigration advocacy groups, arguing that the categorical application of a financial bond requirement to all citizens of designated countries raises constitutional and statutory concerns. The outcomes of those legal challenges, if and when they are decided by federal courts, could significantly affect whether and how the bond requirement continues to be implemented. Additionally, the diplomatic response from affected countries, which in some cases have been discussing reciprocal measures or formal diplomatic objections, could also affect the policy's future. Immigration attorneys, diplomatic analysts, travel industry experts, and civil liberties advocates have all weighed in on the $15,000 visa bond requirement and its expansion, and their perspectives provide essential context for understanding both the rationale behind the policy and the legitimate concerns it raises. Immigration attorneys who work with clients from affected countries have been among the most vocal critics of the bond requirement, raising both practical and legal concerns. On the practical side, these attorneys note that the $15,000 amount creates an insurmountable financial barrier for many legitimate visa applicants, effectively creating a wealth test for access to U.S. visas that has no clear relationship to the applicant's likelihood of complying with visa terms. A wealthy applicant who intends to overstay faces no greater financial burden from the bond than any other wealthy applicant, while a low-income applicant with entirely legitimate travel plans and a genuine intent to return home cannot post the bond at all. The attorneys argue that this distributional impact is both unjust and counterproductive to the stated goal of reducing visa overstays. Diplomatic analysts who study U.S. foreign relations have raised concerns about the broader geopolitical implications of the bond requirement and its expansion. They note that the categorical application of a financial bond to citizens of specific countries is perceived by those countries' governments as a discriminatory measure that singles out their citizens for treatment that citizens of other countries do not face. According to recent statements from affected governments, several of the newly targeted countries have lodged formal diplomatic protests, and some are discussing whether to implement reciprocal measures that would impose similar or equivalent requirements on American citizens seeking visas to their countries. These potential reciprocal measures could affect American businesses, tourists, and professionals who travel to the affected countries. On the other side of the debate, immigration enforcement advocates have supported the bond requirement as a rational and lawful use of existing statutory authority to address a genuine and documented problem of visa noncompliance. These voices argue that the overstay rates from affected countries represent a real immigration integrity challenge that the previous approach of warnings and denials had failed to adequately address, and that a financial deterrent creates a meaningful incentive for compliance that other measures do not. They point to the existence of the statutory authority for bond requirements as evidence that Congress contemplated exactly this kind of use and built it into the law deliberately. Let us bring this policy down to the level of real people and real consequences, because behind every statistical discussion of visa overstay rates and bond amounts are individual human beings whose travel plans, family connections, professional obligations, and dreams are directly affected by this requirement. Think about a graduate student from one of the newly designated countries who has been accepted to a prestigious American university for a doctoral program and who needs a student visa to begin their studies. The $15,000 bond requirement now stands between them and the visa that would allow them to pursue the academic opportunity they have worked toward for years. The student's family in their home country does not have $15,000 available to post as a bond, and the student themselves, who will be living on a graduate stipend while studying, certainly cannot provide it. The university that accepted this student, which was counting on their enrollment and contribution to a research program, faces the prospect of losing them to a university in another country that does not impose such a barrier. Or consider a family where parents who are citizens of a newly designated country want to visit their adult children and grandchildren who are U.S. citizens or permanent residents. The grandparents are retired, living on modest pensions in their home country, and do not have $15,000 available to post as a bond for a tourist visa. The American grandchildren will not be able to have their grandparents present for important family milestones, graduations, or family gatherings, not because of any immigration risk, but because of a financial requirement that is simply beyond the family's means. The human cost of this separation is real and significant, and it is borne by the American citizens in the family just as much as by the visa applicants abroad. For the tourism and hospitality industries in the United States, the expansion of the bond requirement to 12 additional countries represents a direct threat to revenue from international visitors. Hotels, airlines, tour operators, cultural attractions, and retail businesses that depend on international tourism from the affected regions face reduced bookings and visitor numbers as citizens of those countries either choose alternative destinations or simply cannot navigate the financial requirement. The economic ripple effects extend from major tourist destinations to smaller communities that have developed tourism industries that serve visitors from specific international markets. Let us close with a clear and complete summary of the most important information from today's coverage. The U.S. State Department has extended the $15,000 visa bond requirement to citizens of 12 additional countries, expanding a pilot program that was already in place for an initial group of nations. The bond is a financial guarantee that must be posted as a condition of visa issuance, and it is designed to deter visa overstays by creating a substantial financial consequence for non-compliance. The bond is returned to the applicant or their sponsor if the visa holder departs the United States in compliance with their visa terms and forfeited if they overstay or otherwise violate their visa conditions. The practical effect of the $15,000 amount is to create a significant financial barrier that may exclude many legitimate travelers from the affected countries from obtaining U.S. visas. Citizens of the designated countries who are planning visa applications should consult the current State Department guidance and consider working with an immigration attorney to understand their options. Legal challenges to the policy are being pursued, and the diplomatic response from affected countries is ongoing and could affect the policy's future trajectory. Anyone affected by this requirement should monitor developments closely and seek qualified legal advice. Before we close out today, we want to hear from you. Are you a citizen of one of the countries affected by the visa bond requirement? Or do you have family members who are? Have you or someone you know encountered this requirement when applying for a U.S. visa? Do you have questions about how the bond works, what your options are, or where to find current information about which countries are covered? Drop your questions and your experiences in the comments section below. This community has members from across the world, and sharing information and experiences helps everyone navigate a rapidly changing and increasingly complex visa landscape. If this video gave you important and useful information about the visa bond requirement, please give it a thumbs up and share it with everyone in your network who is from or connected to an affected country. Subscribe to U.S. Benefits Update and turn on your notifications so you never miss a critical immigration or visa policy update. I am Claire Hollister, and thank you so much for watching today. We will see you in the very next video.